Good afternoon if you are watching this during the regular class period. Today we're going to talk about creative property, what you would know probably better as copyright law. And so as we're going into this, the big questions are, why would you want to know about copyright? That'll be pretty easy to answer. What can be copyrighted, and by extension, what cannot be copyrighted? And then the ultimate question that we're going to talk about today is what are fair uses of a copyrighted work? So let's dive in. First, why would you want to know? Well, in this class, we have a lot of creative people. You are creating works and you want to know your rights. Is my work protected? What are my what are my rights if I'm working for another company? What if somebody infringes my rights? What can I do? But also, we are creative people, and we often want to use someone else's work in our videos, in our social media posts, in our movies, on our websites, in our articles. We want to use other people's photos, other people's clips of videos, other people's text, and we want to know if we can use it or not. So let's dive in. What can be copyrighted? According to the Copyright Office and the Copyright Act of 1976, there are these categories, these 8 categories of things that can be copyrighted. Literary works, that makes sense. Books, magazines, things like that. Musical works, that makes sense. Music. Dramatic works, and so plays and musicals and things like that. Pantomimes and choreography. This may be something that you didn't necessarily think could be copyrighted, but it can. So the choreography in a musical could be separately copyrighted. Pictures, graphics, and sculptures, artwork, that's another thing that we would assume can be copyrighted. Motion pictures and other audiovisuals, so motion pictures, television, videos, things like that. Sound recordings. You may go, hey, we already have musical works. Well, the music, the sheet music, and the words can be copyrighted, and then the actual recording can also separately be copyrighted. And then finally, the category that you're probably not going to care about is architectural works, but the blueprints, the design of a building can be copyrighted. All right, so if these are the categories of what can be copyrighted, what cannot be copyrighted? There are 4 categories of what cannot be copyrighted. So the first thing that you need to understand is that works that have not been fixed in a tangible form of expression cannot be copyrighted. Ideas cannot be copyrighted. So, for example, let's say I've got this great idea for a movie, and I have this idea, and it's about a guy and a girl, and they fall in love, and they're on this boat. But then the boat runs into an iceberg, and the boat sinks, and the guy dies, but the girl lives on, but she's heartbroken, even though her heart does go on. And you're probably sitting there going, yes, I know, you're talking about Titanic. The thing is, I may have that idea, but until I write the idea down in a story form or in a treatment form in Hollywood, like a little 2-page treatment, or I shoot and edit it, or until I take that photo, just because I had the idea of something, it's not copyrightable until I fixed it in some kind of tangible form. I have to take the photo, I have to shoot the video, I have to write the lyrics, I have to play the music, whatever. Secondly, trivial matters cannot be copyrighted. These are things like titles, names, little short phrases, or slogans. All right. These things cannot be copyrighted because when you copyright something, that means that if anybody makes a copy of that piece, then they have to pay you. And so I can't copyright the word Star Wars And because those are two words, star and wars. And when you put them together, I cannot copyright something that simple, that, you know, trivial. Now, you may be going, well, but Star Wars is Lucas and Lucasfilm, they own that. Well, they don't even own the copyright to it. They own the copyright to the whole movie called Star Wars, but the title in and of itself is not copyrighted. Now, it is trademarked, and that's a different thing, and we'll talk a little about that next class period. But these short things cannot be copyrighted. You cannot just copyright, a word, unforgiven, copyright Chris Blair. No one else can use this word because, I didn't come up with that word. And I didn't come up with this little short phrase. And so some of these short phrases and slogans can be trademarked. They just can't be copyrighted. Then, methods, systems, mathematical equations, and formulas. These are things that cannot be copyrighted. And the logic behind that is all of these kind of mathematical equations and formulas and things are not copyrighted because they were not created by the mathematician who came up with them. They were discovered that they already existed in nature, in reality, that equation existed, it was true, and a mathematician may have discovered it. Now, a little caveat there, a mathematician cannot copyright, E equals mc squared. Einstein couldn't copyright that, but he could copyright his printed explanation about why that equation is significant and what it means. So other people are welcome to use E equals mc squared, but they couldn't use his explanation without giving him credit or money. And then finally, information that is commonly or common property with no original authorship. So if I create a calendar, if I figure it out and I create the year 3000 calendar and publish it, and then somebody else comes out with their own year 3000 calendar, it wasn't my creative property. It already existed. There were lots of cases that came out about like phone books. The phone company created a phone book, but then other people started creating their own independent phone books, and there were yellow pages and things like that. And so phone companies sued, saying, this is our thing, we created it, and they just copied all of our information. But the reality is, the name of a person, where they live, and their phone number is common property. It's not owned. It wasn't really created by the phone company. And so things like that can be created by anybody, and it's not copyrightable. So you create something. Let's say you create something that is truly copyrightable. You take that photo, you write that screenplay, you create that website, you write that article, you take, whatever it is. How do you copyright it? There are three parts or three steps to it. Anytime you register a copyright, you have to register a copyright with the Copyright Office. The Copyright Office is a branch of the Library of Congress. And the Copyright Office has a registration form. You have to fill it out. There's an online form available that you can find at copyright.gov. And then you have to pay a filing fee, and it depends on what type of work you're submitting and how you're submitting it, whether physically or electronically. You pay either your $35 or your $55. And then kind of the traditional mentality is you have to deposit 2 copies of the work to the Copyright Office so that they can place it in the greater holdings of the Library of Congress. But some work can now be submitted electronically. When I was finishing my PhD, I wrote my dissertation. And to have my dissertation submitted to the Dissertation Abstracts International, it had to be copyrighted first. So I had to register the copyright for my dissertation. My dissertation was 396 pages long. So I had to print 2 copies of my dissertation, bind them together, and ship them off with the registration form and a check to the Copyright Office. It's become easier now being able to submit things electronically. When you register a copyright, you get a form back, that says that, congratulations, this is copyrighted, and it just has the name of it and that it was accepted and it was, they double checked to make sure that it was an original work and it was granted a copyright. Now, there are a lot of things that are copyrighted but aren't registered for a copyright. And so, what's the difference? Well, there are lots of people who create copyrighted work, and a work is copyrighted as soon as you create it. So, if I take a photo, it is copyright me, but it's not registered to be copyrighted. And so, if someone used my photo and I wanted to take them to court, I would need to have it registered to take legal action. Great example of this was there was a photographer in Louisiana who did high school senior photos. Well, he took hundreds of high school senior photos. Of course, he copyrighted. He wanted these to be copyrighted. He didn't want people to make copies of his photos without his permission or him being able to make money. But he did not take every individual photo and submit it to the Library of Congress, the Copyright Office, and pay $35 per one. And you can bundle them together, but still, that would be cost prohibitive. So he just, moved along as normal, put, do not make copies, contact me or whatever on the back of the photos. But one day he got a phone call from a individual saying, did you take a photo of so and so back a few years ago? And he had to go back and look at his records, and he went, yeah, I took that. Why are you asking? He was like, because I saw your photo. I figured it was yours on the news tonight because the photo he took was I don't remember the guy's name, the guy who married Britney Spears in Vegas, her former boyfriend or whatever, who she hooked up with in Vegas. They got married and then it got annulled a couple of days later. And it was big news. So everybody was clamoring for a photo of this guy, and people were starting to use his photo. So what he did is he contacted an attorney and quickly got a expedited copyright registration for that photo so that he had printed, verifiable proof that he owned the copyright for it. Then he contacted news outlets and, CNN and, the newspapers and television and said, hey, you're using my copyrighted photo. This is what you need to pay me, to use it. And, he wasn't like he wasn't rude about it, but it is his right. And he made he made tens of thousands of dollars off of those few weeks on that one photo, but he had to have it registered. All right. Whether you have a registered work or not, you should clarify that it's copyrighted by putting a proper copyright notice. And a proper copyright notice is the year it was created or copyrighted, the copyright symbol, the C with the circle around it, and then your name. Now, in the United States, you can spell out copyright, COPRIGHT, but internationally, because we don't all speak English, the C is kind of the internationally recognized symbol, and so I would go with that. Also, make sure that you're using your actual name. We run into this a lot with like our student productions of like short films. They put at the end of it, copyright 2018, copyright, I better get an A on this productions. And that's kind of cute, but it has no legal standing because who is, I better get an A out of this productions? Unless you've like registered that as a production company is incorporated in the state of Tennessee, then nobody knows who that is, and it'll be more difficult for you to try to seek, legal remedy if somebody used your work. So you have a copyrighted work, but the big question is, how long does that copyright last? Well, it depends. It's relatively complicated. Let's start with older things, maybe that you want to use, and then we'll talk about the things that you create. According to the Copyright Act of 1976, which is the law that we're under, anything published prior to 1923 is in the public domain. Really old movies, silent movies from the early days, photos, things like Shakespeare, and books from classic authors are in the public domain. You can take that information and lay it out and publish a book or use that movie, and there's no big deal. But if somebody takes like a work that was created in 1915, it would normally be in the public domain. But let's say then they remastered it, like a movie, they cleaned it up, they remastered it, and then they released it on a DVD or a Blu ray in 2018, then it would be a new copyright. So you do have to be careful with some of these things. But if things published before 1923 are in the public domain, what about things after that? Anything published from 1923 to 1963, the copyright duration is 95 years if the copyright was renewed at the 28-year point. And that's kind of a carryover from the previous Copyright Act, the Copyright Act of 1910, where you had to renew it at the halfway point, and copyrights were for 56 years. But a lot of things are still copyrighted, and so you have to be careful. Now, what about things from 1964 to 1977, when the new Copyright Act took effect? They go for 95 years, because, of course, all of those things were before that first renewal period. But if it was created but not published before 1978, it has the same rules that we follow, which is if something was created after 1977 and there's just one author, so I took the photo, I wrote the book, whatever, the copyright lasts the author's life plus 70 years after they pass away. And that lets them benefit from their creative work their entire lifetime, but then also benefit from it. Their estate can benefit from it after that. What if it has multiple authors? So you worked with a couple of people. Well, it's whoever lives the longest. So the longest life plus that 70 years. So if you really want a really long copyright, you need to collaborate with somebody who's really young and really healthy. But that's joint authors. But what if it's a work for hire? And what does that mean? It means that, yes, you may have created something or you helped create something, but the copyright vests or is owned by a corporation. Corporations don't die most of the time. And so they could live on forever with the copyright. So there are different rules for companies that own the work. And for a work for hire, it's 95 years from the first publication, so if it's released or published in some way, or 120 years from its creation, whichever comes first. And that may sound complicated, but sometimes things are created. Somebody takes a photo and it just sits in a drawer and it's not published for a long time. And so either, let's say it was shot in 1950, and then it was released for the very first time in the year 2000. Well, which one would come first? 95 years from the first publication would be 2095. But that means that it would be protected for 145 years from when it was first created. That's not possible. So it would be 120 years. So if it was released in 2000, but it was actually taken in 1950, then it would be 120 years from 1950, which would be 2070. Now, we have talked a lot about what can be copyrighted, what can't be copyrighted, how long does the copyright last, how do you get your copyright. And in general, the rule is if you have a copyright, then no one can make a copy of your creative work without your permission or paying you money unless it's a fair use. So how do we determine what is a fair use? Well, that's the complicated part. And there's a four-part test, and because Congress and the government loves four-part tests, the four branches or the four elements of fair use are the purpose and character of the use, the nature of the copyrighted work, the amount of the portion used, and then the effect on the potential market value of the work. Now, that's a lot of terminology and everything. Let's break that down one by one. So first of all, let's look at the purpose and character of the use. So this has to deal with how are you taking somebody's copyrighted work and using it. Here we have our little slide. On one side of the continuum, let's say, on one side, you have non-commercial use. And that, like, nonprofits, you're not making any money off of it. Educational use, there's widespread freedom in educational use. This side of it, so the things over here on the left, lean toward fair use. Now, on the other side is commercial use. So I'm taking that DVD, I'm making copies of it, and I'm selling it at a flea market. Or I am taking your photo and I am selling it. I'm making copies and I'm selling it. And so, that would be commercial use, but that's not the only commercial use. Maybe I take your photo and I'm not selling your photo, but I use your photo for an ad promoting my product. Well, I'm gaining commercial benefit from the ad benefit. And so that would also be considered commercial use, even though I don't necessarily make a dime off the use of your photo. I am gaining benefit. So things that are purely commercial would lean toward infringement, not fair use. All right. But then there are these mitigating factors here in the middle. The criticism, commentary, news reporting, parody, and transformative uses. And all of these things, even if something is highly commercial, if it's criticism, so someone writes an article that's critical of a movie, but they are critical of a book and they use excerpts from the book, or it's critical of a movie and they use little clips from the movie, it may be commercial, but it's for the purpose of criticism, so it helps mitigate that and lean it towards fair use. The same for commentary, news reporting, and so if a newscast uses video from something that's copyrighted or a photo or text, then they have some special protection, even though they're making money off of the broadcast. Parody, we'll talk about next class period specifically, and the whole concept of the transformative use. If you remember that from the episode of The Good Wife that we watched, we would argue that this is a transformative work of art. And so all of these things tend to mitigate the character of the use back toward fair use. So, imagine this like on a scale from 1 to 10, with purely commercial, let's say educational use being over on 0 or 1, and then purely commercial use all the way over at 10. And so you kind of weigh that. And so does it weigh towards fair use or does it weigh towards infringement? Then you look at the work, the nature of the work that's being used. And the big questions here are, is the material factual or is it imaginative, more creative? So if somebody writes a history of World War II, and in it they say on December 7th, 1941, the Japanese attacked Pearl Harbor, and then you write a book that says on December 7th, 1941, the Japanese attacked Pearl Harbor. You have taken their work. Well, not really, because there's only so many ways that you can say that. It's historical information that you're using. But on the flip side, like a screenplay or a story that's completely fictional or imaginative, that's going to be leaning heavily towards infringement. So factual is leaning towards fair use, imaginative towards infringement. Also, if a work has been published, if it's already out there, if it has had the benefit of having people see it and associating that author with the work and them already benefiting financially from their work, then it has a little less protection than something that is unpublished. And so unpublished work is leaning more towards infringement because they haven't really had the benefit of benefiting from the copyright. And so if you beat somebody to the punch of publishing it, then you're going to be treated a little more harshly. So what's the third element? It has to do with the amount of the work used. And these are highly technical terms here. On one side is a small amount. On the infringing side is a large amount. And so if I use like 5 seconds from a movie in my clip, officially, it's making a copy of a copyrighted work, but it's just using a small amount for maybe a specific purpose. Whereas if I make a copy of the entire movie and upload it on YouTube, then it would be a large amount or the entire amount. But also understand, though, that it is somewhat mitigated by the character of the use. So if I use a small amount for commercial purposes, it may still be considered infringement. Whereas if I may use a large amount, but it's like for educational use, then it's still going to be considered fair use. All right. Then the big question is, what is the effect on the potential market value of the work? Did your use of the copyrighted work negatively affect the value of the work? And so some of these questions come up. So is the original out of print or unavailable? So if no one has been publishing that book or that movie or something for decades, and you find a copy of it and make it available, then it's still somebody's copyrighted work, but it's not going to be considered as gross a violation as if you get the movie that came out this weekend and upload it and make it available. That's going to be a big deal. Is the copyright holder unidentifiable? Is there any way maybe you find a film at a yard sale and you try to find out who created this work and no one knows, then even though you may use this and someone may eventually come and go, hey, I created that, you're not going to be treated as harshly if you could not find out who the copyright holder was. Does your use of the work compete with the original work? That's a significant question. Is there a ready market for permission? What does that mean? Well, is there like a whole system? Like, for example, if I want to show a movie and we want to have movie night, like the SAC movie night or movie on the lawn here at the university, there is a ready market for permission. There's a company that we can contact, and they rent out movies for public exhibition. And so they will send you a Blu-ray of the movie, but then they will send you a license to show it for a audience larger than a home audience. And so, and those usually cost a little more money. So like a popular movie that maybe came out last year, you're probably going to have to pay like $350 to show that movie in public. And so that may seem like a big deal, but compared to what people had to pay to show it in the theater, it's actually pretty reasonable. But if I just showed a movie on the movie on the lawn, I just went to the library, grabbed a movie, and showed it, and they filed suit against me, they would be asking the question. There was a place you could have gone to Swank, which is the company that manages this easily, and contacted them. Why didn't you? And then finally, did your use avoid payment in an established permissions market, which is kind of like what I just talked about? All right. So the elements that we talked about, you have to understand that the character of the use, the nature of the work, the amount used, all of it is kind of filtered through. But what was the effect on the potential market value of the work? So understanding fair use is helpful. Unfortunately, there's not like easy, hard rules that we can follow. There are some people who believe if I just use 5 seconds of a song, that I'm okay. Well, that's not necessarily true. It has to do, you have to go through these 4 questions. And the problem that we have is it really has to be decided by the courts. Because every person who's using a copyrighted work will go, hey, no, I'm leaning towards fair use. But every copyright attorney seems to be going, no, everything is infringement. And so if every copyright holder thinks everything is infringement and every creative person thinks everything is fair use, then the courts have to give us some framework. Let's look at one of those cases. This is a case that comes shortly after the Copyright Act of 1976 was enacted, and let's dive into the details here. Harper and Row, a publisher, attained the rights to publish President Gerald Ford's memoirs. It's going to be called A Time to Heal, and the key significance was Gerald Ford was going to explain why he pardoned Richard Nixon after the whole Watergate thing. And so, the book is really not as much the issue here, but Harper and Row contracted with Time magazine for the rights for a preview article. It was a preview of the work immediately before publication. And Time magazine paid Harper and Row $25,000. They were going to pay them $12,500 up front and then $12,500 after they published the article. But before they could publish their article, Nation Enterprises, publisher of the Nation magazine, got a copy of the Ford manuscript, and they published an article that quoted the manuscript about that Nixon pardon that everybody really cared about. So Time magazine got scooped. So they no longer had this exclusive article, so they refused to pay the second half of their deal and didn't run their article. So the plaintiff, Harper and Row, who lost $12,500 in this, sued Nation Enterprises for copyright infringement. The district court ruled in favor of Harper and Row. They awarded damages for copyright infringement. Nation Enterprises appealed. The Second Circuit Court of Appeals reversed the decision, holding that Nation Enterprises' use was fair use under the Copyright Act, Title 17, United States Code, Section 107. And their argument was Nation did not use that much information, that they just used little short excerpts, and so as a result, it was fair use, and that it was newsworthy. And so that was their logic. Harper and Row appeals, and they appeal to the United States Supreme Court. They decide to hear the case, and they reverse the reversal, ruling in favor of Harper and Row. They argued that the selected quotes that were used were the heart of the unpublished work. But more significantly, the Supreme Court walked through the four elements, the four factors of fair use. They looked at the character of the use, and they argued that it was commercial and that the character of the use was for Nation Enterprises to scoop Time magazine. Also, the nature of the work used, the fact that this had been unpublished, and this was information that only Gerald Ford had access to, leaned towards infringement. Again, when they looked at the amount of the work used, they ruled, yes, it was not all of it, but they used the heart of it. And then finally, when they looked at the effect on the potential market value of the work, that was pretty easy. Harper and Row was going to get an additional $12,500, and because of this article, they lost that money. And so they could show damage. So the significance of this case is that it was a clear application of the four factors of the fair use doctrine from the Copyright Act of 1976. It gave guidance to future cases. It also made clear that the publication of parts of a work soon to be published does not qualify as fair use. The two factors most relevant in this case were the purpose of the use. They were very clear about Nation's intention to scoop Time magazine, and the effect on the market value of the work and the harm that happened to Harper and Row. The effect on the market of such a use is shown by what happened here. It greatly decreased the market value of a copyrighted work, And that's really the key when you're looking at copyright cases. Next class period, we will continue talking about copyright, and we will be looking at kind of special problem areas such as piracy and contributory infringement. So just continue your reading, and I will see you on Tuesday.